$31 million. That's what a federal jury made Ted Lerner's company pay Lord & Taylor in 2015 for closing a profitable mall on purpose. Lerner was a real estate billionaire. The lease he signed in 1975 said the mall had to stay open until 2042. He closed it in January 2015 anyway, 27 years early. Why? Because Lerner owned 43 acres on Rockville Pike outside Washington, D.C., and he had a redevelopment plan worth more than keeping the mall open. 4 office buildings, a 300-room hotel, 2,500 apartments. The mall was in the way. The jury read the 1975 covenant. The jury did the math. Lerner had a problem in 1975. He owned 43 acres on Rockville Pike in North Bethesda, Maryland, just north of the Washington, D.C. line. Good land, highway frontage. The county wanted retail there. The banks wanted to lend on retail there. You cannot build an 850,000-square-foot mall on a hope. You build it on tenants. And in 1975, the tenants who mattered were the anchors. Lord & Taylor, Bloomingdale's, Sears, J.C. Penney. With no anchor, the smaller stores would not sign their leases. With no smaller stores, the bank would not lend. The math ran in one direction. Mall developers chased department stores, and department stores knew it. Lerner needed Lord & Taylor. He needed Bloomingdale's, so he gave them what they asked for. The anchors did not pay mall rent the way a shoe store paid mall rent. The anchors leased the land their buildings sat on, often for token amounts. They built their own buildings. They ran their own hours. And they signed contracts that gave them control over the rest of the property. That document at White Flint had a name: the Reciprocal Easement Agreement, the REA. It said Lord & Taylor would commit decades of presence and foot traffic to the site. In exchange, Lerner Enterprises and its partner, the Tower Companies, committed to one specific promise. White Flint Mall would operate as a first-class, high-fashion shopping center. Not a strip plaza, not a fast food alley, a first-class mall, with Lord & Taylor as one of 2 department store anchors next to Bloomingdale's. The promise ran until 2042. The contract said the obligation ran with the land, meaning whoever owned the property in the future was bound by the same terms. Sell it, refinance it, hand it down to your children, the clause survived. Lerner needed Lord & Taylor, so he signed. 2 years later, in 1977, White Flint Mall opened its doors. Lord & Taylor on one end, Bloomingdale's on the other. The mall was a statement when it opened. 3 levels of shops instead of the standard 2. Glass-enclosed elevators that the locals had not seen at a suburban shopping center until then. Japanese gardens, valet parking, a deck parking structure for the cars, and one detail that no other American mall had. White Flint introduced the first mall-branded credit card in U.S. retail history. The Washington Post called it the posh White Flint Mall in a 1977 headline and described what the developers had built as a high-fashion shopping center designed to fill a merchandising vacuum in the upper-income Montgomery County market. For the first time in American retailing, Lord & Taylor and Bloomingdale's stood face-to-face under the same roof. The covenant Lerner had signed sat in a filing cabinet, doing nothing, asking nothing, year after year. For 35 years, that paper was the cheapest contract Lerner Enterprises had ever signed. White Flint Mall worked. That was the part that mattered for 30 years. Lord & Taylor sat on one end, Bloomingdale's on the other. Bloomingdale's at White Flint was the second Bloomingdale's the Washington, D.C. area had ever seen, after the one at Tyson's Corner. Bloomingdale's grand opening at White Flint was February 26, 1977. Lord & Taylor opened its doors a few days later on March 1, 1977. From that point forward, those 2 anchors operated continuously at White Flint for the next 3.5 decades. Bloomingdale's stayed until 2012. Lord & Taylor stayed 43 years until the chain's 2020 bankruptcy closed the store down. The mall was the high-fashion suburban shopping address in the upper-income D.C. suburbs, and Montgomery County had no real competitor for that title. For a long stretch, this was the only place in suburban Maryland where you could walk through Bloomingdale's, walk through Lord & Taylor, and walk through dozens of other stores in the same afternoon. Saturday afternoons at White Flint were a specific thing. The fountains ran, the food court filled up, P.F. Chang's served lunch crowds that packed the place every weekend. The teenagers loitered. The retirees walked laps. Through the 1980s and 1990s, the mall was the upscale shopping address for the northern D.C. suburbs. Anchor tenants matter for a specific reason. Big stores draw foot traffic. Smaller tenants feed off that traffic, paying the rent that keeps the lights on. Pull an anchor out, and the whole machine stutters. As long as Lord & Taylor was open at one end and Bloomingdale's at the other, the anchor was still there. The math worked. Lerner Enterprises collected the rents. The tower companies collected the rents. The two companies had built the mall, financed it, and were now getting paid back many times over. The covenant from 1975 was a piece of paper in storage. It said the mall had to stay first class until 2042, and the mall was first class. The contract asked nothing because the math asked nothing. That part ended in 2010. In 2010, Montgomery County approved something called the White Flint Sector Plan. Government documents are dry. This one was not. The plan rezoned the Rockville Pike corridor for what planners called walkable, urban, mixed-use density. Translation: the county wanted apartments, offices, hotels, and street-level retail packed together. Less suburban mall, more downtown. Lerner was shrewd. He saw the document for what it was. His 43-acre site, that mall and its parking lot, had just been given permission to become something 30 times more valuable. Not 850,000 square feet of mall. Something close to 4 million square feet of buildings stacked, mixed, and rentable. Across Rockville Pike, a real estate company named Federal Realty was already moving. Federal Realty controlled a parcel half a mile from White Flint. In 2014, Federal Realty opened the first phase of a project called Pike and Rose. Pike and Rose was exactly what the sector plan asked for. Apartments above retail, restaurants on the sidewalk, people living, walking, eating, shopping. The kind of density that brings the kind of money that mall rents could not generate on their best Saturday. Lerner had a problem. He had a mall that was paying him rent. He had a piece of paper from 1975 that said the mall had to stay first class until 2042. And next door, a competitor was building the kind of urban village that would, within 5 years, make his suburban mall look like a relic. In November 2011, Lerner Enterprises announced the plan. The mall was coming down. 4 office buildings, a 300-room hotel, 1 million square feet of new retail and restaurant space, 12 apartment buildings, 2,500 units, a new urban district. The Pike District, the county was now calling the whole corridor. Bloomingdale's saw the writing on the wall. In March 2012, the White Flint Bloomingdale's closed. The building came down the following year. From that point forward, Lord & Taylor was the only anchor still standing at White Flint. Lord & Taylor saw the same writing on the wall, but read it differently. In July 2013, the department store sued Lerner Enterprises in United States District Court for the District of Maryland. The lawsuit asked the court to issue a permanent injunction stopping the redevelopment entirely. Lord & Taylor argued the redevelopment violated the 1975 covenant that the new vacancy rate at the mall had climbed past 40% because the owners were deliberately starving the mall of tenants, and that the planned demolition would destroy the anchor location the covenant protected. The 2013 lawsuit effectively froze the redevelopment timeline. Lerner Enterprises could not begin demolition while the lawsuit was alive, so the mall sat half-empty. The redevelopment sat on hold, and the lawyers on both sides settled in for a multi-year fight. The sector plan was the green light. Pike and Rose was the proof of concept. The 1975 covenant was the line item the plan ignored. The mall did not close all at once. It shed tenants for 2 years while Lord & Taylor's 2013 lawsuit worked its way through the federal docket. Stores moved out of the inline spaces. Kiosks shut down. The food court started looking thin on weekends. Lerner Enterprises was running a clock, and the tenants could read it. By late 2014, only a handful of holdouts remained, and the corridor was openly waiting for the demolition crews. The vacancy rate Lord & Taylor would later cite in court at over 40% was easy to verify just by walking the place on a weekend. Lord & Taylor stayed. The Bloomingdale's building was already gone. Lord & Taylor's department store was the last anchor on the property, standing on its own land, under its own building. Lerner did not have the right to make it leave. January 4, 2015 was a Sunday. P.F. Chang's at White Flint served its last meal that day. So did the few inline tenants still operating. After the dinner rush, the mall closed its main concourse for the final time. The doors locked. The fountains stopped. Maintenance stacked the food court chairs. The mall that had run for 38 years was over. Lord & Taylor stayed open on its own land, still selling clothes to whoever drove out to Rockville Pike. Around it, the mall concourse was dark. Lerner Enterprises had made a specific calculation. The lawsuit was already pending. The trial was scheduled to begin July 28, 2015. If the mall was already closed by the time the case went to a jury, an injunction to keep it open would be moot. The judge would be deciding damages, not orders. Damages were a number Lerner could pay. An injunction was an obligation he could not work around. Closing the mall in advance of the trial was the way to convert one kind of legal exposure into the other. Lerner was a billionaire. He had real estate attorneys, the appellate process, and time on his side. A jury would have to award damages so large they outweighed the value of the new project. That kind of award was not common. He made the BET. 6 months later, that bet went to trial. Lord & Taylor had filed the case in the United States District Court for the District of Maryland back in July 2013. The case was assigned to Judge Roger W. Titus. The complaint was direct. White Flint Limited Partnership, the entity that Lerner Enterprises and the tower companies used to hold the mall, had breached the 1975 Reciprocal Easement Agreement by closing the mall and starting demolition. The covenant required White Flint to operate as a first-class shopping center until 2042. By the time the trial began on July 28, 2015, the mall had been closed for 6 months. The breach was finished. The only question was the size of the check. Lord & Taylor's case at trial was sharper than the original 2013 injunction complaint. Their lawyers told the jury that the mall owners had poisoned the property to force the closure. They argued Lerner Enterprises had deliberately allowed the mall's vacancy rate to climb past 40% in the years leading up to the closure, refusing to renew leases, refusing to backfill departed tenants, signaling to the entire retail world that the mall was on death row. The poison was the strategy. The closure was the cover. Lerner's lawyers had a defense. They argued that the covenant required the developers to maintain the property, but did not require any specific level of tenant occupancy. The term first-class shopping center was vague, undefined, subjective. The redevelopment plan was an evolution of the property, not an abandonment of it. And Lord & Taylor had not suffered actual damages because the store was still open and still profitable next to the empty concourse. The trial was scheduled for 8 days. It ran 10. The jury was 12 people pulled from Maryland zip codes. Judge Titus read the jury instructions himself. The covenant was read aloud in open court. The evidence stack included the 1975 signatures, the mall's last year financial records, the sector plan documents, the Pike and Rose lease numbers showing what Federal Realty was charging across the street for the kind of project Lerner wanted to build, and Lord & Taylor's expert testimony on what an anchor location near an active mall was worth versus an anchor location next to an empty parking lot. 12 ordinary people sat through 10 days of testimony on anchor tenants, foot traffic models, covenant law, the the economics of dying malls, and the difference between a covenant and a commercial inconvenience. They listened to a real estate billionaire's attorneys argue that a 40-year promise was vague. Then the jury went into the deliberation room and stayed there for more than 2 days. The jury came back on the second full day of deliberations and delivered the verdict on August 14, 2015. The jury found that White Flint LP had breached the 1975 Reciprocal Easement Agreement. They awarded Lord and Taylor $31 million in damages. $31 million. That number was not pulled from a hat. The jury had been walked through the math by Lord and Taylor's experts over the previous 10 days. The covenant said the mall would draw foot traffic until 2042. The mall was now dark. The store's projected revenue from foot traffic shoppers multiplied across the remaining 27 years of the covenant, plus the loss of value to the building itself, plus expert testimony on what a dead mall anchor location was worth versus a live mall anchor location, added up to a number: $31 million. News of the verdict landed in the regional real estate press within hours. The Daily Record's headline read, "Lord & Taylor wins $31 million award in White Flint Mall dispute. The covenant defense had not held." The jury had told a billionaire that a 40-year-old promise still ran with the land. The American Bar Association picked up the story and ran a write-up the following year. Real estate trade publications followed. Industry attorneys who had spent decades treating mall operating covenants as soft promises started reading them like contracts again. The White Flint verdict sent a clear message to every mall owner sitting on a 1970s anchor deal. If you signed a covenant to keep the mall open and you closed it on purpose to redevelop, an anchor tenant could collect at the courthouse. $31 million was now the going market rate. The court entered judgment in favor of Lord & Taylor in 2015. Lerner Enterprises and the tower companies were on the hook for every dollar. The redevelopment plan that was supposed to be worth so much more than a lawsuit had just bumped into a $31 million line item. And the redevelopment plan had a second problem on top of that. The county had approved it. The architects had drawn it. But the demolition could not begin while the verdict was on appeal. Lerner Enterprises was building nothing while paying lawyers to argue why they should not pay the verdict. The mall site sat empty. Lord & Taylor's department store sat next to the empty concourse, still selling clothes. And in the lawyers' offices in Bethesda and Washington, the appellate briefs were being prepared. Lerner appealed. The appeal went to the Fourth Circuit Court of Appeals, case number 15-1995. The three-judge panel was Judge Harvey Wilkinson, Judge G. Stephen Agee, and Judge Pamela Harris. They sat in Richmond, Virginia, and read every brief, every transcript, every piece of evidence the trial court had handled. Lerner's lawyers tried again. They argued the same theories that had failed in the trial court. The covenant was vague. The trial judge's jury instructions were flawed. The damages award was speculative. The redevelopment was an evolution of the property, not an abandonment of it. Lord & Taylor's expert testimony on damages methodology should have been excluded as unreliable. Judge Titus, they argued, had given the jury too much rope, and the jury had hanged the wrong party. On February 28, 2017, the Fourth Circuit handed down its opinion. Judge Pamela Harris wrote the unanimous decision. Judges Wilkinson and Agee joined every paragraph. The verdict was affirmed. Every dollar. The three appellate judges agreed with the jury, agreed with Judge Titus, and agreed with Lord & Taylor. The 1975 covenant meant what it said. The breach was real. Lord & Taylor's experts had calculated damages correctly. Judge Titus had instructed the jury properly. A 40-year promise was a promise. Lerner Enterprises and the tower companies now owed Lord & Taylor $31 million, plus interest, plus costs. In July 2018, 3 years after the trial and over a year after the appellate ruling, the lawyers were still fighting. White Flint LP was contesting a court costs bill. Lord & Taylor had submitted an invoice for $110,000 in court costs. Lerner's side was arguing it was too high. A billionaire's company, which had just been hit with a $31 million verdict and a unanimous appellate affirmance, was quibbling over a $110,000 invoice. The court did not buy it. There is a comment people leave under videos about dying malls. Court system failed these malls, they write. Not at this mall. At this mall, the court system worked exactly the way it was supposed to. A jury read the covenant, a judge entered the judgment, and 3 appellate judges affirmed every word. 12 people from Maryland told a billionaire that a 40-year-old promise was still a promise. The redevelopment was about to find out what that promise actually cost. The check was written. Lerner Enterprises and the tower companies paid the judgment. $31 million went to Lord and Taylor. The lawsuit was over. The demolition started. The shell of the old mall came down. The food court, the corridor, the parking deck, all of it. By fall 2023, the last piece of the 850,000 square foot mall was gone. Only the Lord and Taylor building remained, sitting alone on the cracked asphalt of the former parking lot, the last shape of what had once been White Flint. In 2020, Lord and Taylor itself filed for bankruptcy. The chain's nationwide liquidation closed every store, including the one that had outlasted the mall it anchored. The Bethesda store closed 43 years after it opened on March 1, 1977. The standalone building on the cracked lot went dark for the last time. Across Rockville Pike, Federal Realty's Pike and Rose kept growing. Phase 1 had opened in 2014. By 2025, Pike and Rose had become a real urban district. Restaurants, residential towers, retail at street level, and tenants paying real urban rents. Everything that the White Flint redevelopment plan had promised, Federal Realty had built half a mile away, while Lerner Enterprises was paying lawyers. By the time Lerner could legally start construction on the White Flint site, Federal Realty had already pulled in. The wealthy renters Lerner's plan was designed to attract. The customer base was a half mile away, in someone else's apartments, eating at someone else's restaurants, shopping at someone else's street-level retail. The land Lerner had bet a $31 million verdict on was now competing against the urban district built next door during the years his project sat frozen. The redevelopment plan that was supposed to be worth so much more than a lawsuit was now ready to be built. 4 office buildings, a 300-room hotel, 1 million square feet of new retail, 12 apartment buildings, 2,500 residential units. The Pike District Urban Village. Construction did not start. By 2026, the 45 acres on Rockville Pike are vacant. 11 years after January 4, 2015, the day P.F. Chang's served its last meal and the mall locked its doors, the redevelopment exists only on paper. The site is weeds and broken concrete and the foundations of a building that came down. Theodore N. Lerner died on February 12, 2023, in Bethesda, Maryland. He was 97 years old, a real estate billionaire many times over, the principal owner of the Washington Nationals, and the man whose 2019 World Series championship came under his watch. Mark Lerner, his son, became the team's managing principal owner. The 43-acre piece of land on Rockville Pike, where his father had built White Flint Mall, remained vacant on the day of the funeral. The next time you drive past a piece of land where a mall used to be, look for the chain-link fence and the weeds breaking through the lines in the parking lot. That is what a 1975 covenant looks like a half-century later. That is what $31 million buys when you bet against a contract you signed.